Hello everyone, welcome back to our channel. I'm so happy that you are still here. Most probably, nakapag-term exam na kayo by now. Hope we have at least helped you somehow. Previously, we have already discussed the general provisions ng obligations, its sources, nature and effects, including the different kinds of obligations. And now, we are down to the last chapter ng obligations bago tayo mag-proceed sa discussion ng contracts. For now, let's start our discussion on the different modes ng extinguishment of obligations. To better understand, I encourage you to watch the whole video. And if you want, you can take down notes para mas ma-retain ng memory ang napanood. If you find this video helpful, paki-like naman. And if hindi pa kayo nakakapag-subscribe, please subscribe na rin and then pa-click na rin ng bell button para mas ma-notify ka if may new upload kami. So, paano nga ba na-extinguished ang obligation? How does it come to an end? Article 12.31 enumerates the different modes ng extinguishment of obligations. Ang mga concepts na to ang iisa-isahin natin ang discussion sa chapter na to. But for today's video, we will be discussing in detail yung first mode ng extinguishment ng obligation, yung payment. Medyo mahaba to. So, para ma-avoid natin yung situations na masyadong mahaba yung video at tsaka mahirap mag-upload on my part. And so, to avoid rin in your part information overload, so i-divide na rin natin ito into parts. For now, simulan na natin with the first mode of extinguishment of obligations. So, Article 12.32. Payment means not only the delivery of money, but also the performance in any other manner of an obligation. So basically, first and foremost, dapat meron muna talagang pre-existing obligation. Kasi kung walang obligation, ay wala rin namang babayaran. There's no payment to speak of in the first place, right? Halimbawa, if si Pogi ay binigyan na pa lang muna ng option to buy yung specific car, okay? May option to buy muna siya. Say within a period of 1 week, pag di pa siya nagde-decide na bibilhin niya yung car na yun, wala pa siyang obligation. But once binili niya na ang car, an obligation to pay on his part now exists. And in order to extinguish that obligation, Pogi needs to pay for the car. Okay? So ano ba ang sabi ni Article 12.32 about sa payment? What is payment? So si payment is not limited sa pagbabayad na alam natin ordinarily. In legal parlance, it has a much wider meaning. Kasama dito ang performance ng obligation, meaning ang payment ay ang pagdi-deliver ng pera or bagay, pag real obligations or obligation to give. And it also includes the doing or not doing of something. Pag yung obligation naman ay personal obligation or yung mga obligation to do or not to do. And like obligee and creditor, obligor or debtor, yung mga terms na yan, yung payment and performance are twin terms. Payment refers to the obligations to give, while yung performance refers to an obligation to do. Okay? Now, it's as simple as that. Article 12.33 na tayo. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. So this provision answers the question, when was debt considered paid? Kailan ba mako-considered na paid na yung obligation? Okay? So may dalawang requisites daw. First is yung integrity of the prestation. Tapos second is yung identity of the prestation. Pag sinabi mong integrity of the prestation, meaning the prestation must be fulfilled completely. Dapat completely delivered or rendered. Hindi pwedeng partial or irregular. Otherwise, hindi mai-extinguish ang obligation. So, example, Pogi bound himself to pay Ganda 10,000 pesos. So Pogi is giving only 9,000 pesos. So Ganda can refuse to accept the 9,000 pesos because the fulfillment is not complete, right? But later, as we continue our discussion, we will find out na may mga exceptions rin tong requirements of integrity na dapat fully paid talaga. Ito is yung pag may substantial compliance in good faith. We will discuss this under Article 1234. Tapos pag may waiver under Article 1235. And then pag may application of payments if the debts are equally onerous. Yun naman is pag nasa Article 1254 na tayo. Now, yung sa second requisites, yung sa identity of the prestation, ang ibig sabihin nito is that yung prestation mismo, yung the very prestation must be delivered or performed. Kung ano mismo ang napag-usapang gawin or ibigay, yun mismo ang gagawin or ibibigay. Okay? Example, if the obligation is to give a car, one cannot fulfill the obligation by giving a house. Okay? Tapos, kung yan yung car na yan yung napag-usapan, yan mismo, kung specific siya. Okay? Hindi pwedeng iba. Sino ba yung may burden of proving payment? Ganito yan. At first, si creditor ay may burden of showing na merong valid debt or may obligation na nag-i-exist. Okay? Pero once na-establish na niya na may obligation nga, si debtor ang may burden of proof na nabayaran niya na. Okay? It is the debtor who has the burden of showing with legal certainty that the obligation has been discharged by payment. Okay? Again, hindi si creditor ang may burden of proof to show na hindi pa siya nababayaran. Si debtor ang dapat mag-prove na nakapagbayad na siya. And one good proof is the presentation of receipt. So, yung resibo mismo. Kaya kayo, if may utang kayo, tapos nagbayad na kayo, manghingi kayo ng resibo. It's your right after all. Okay? So, that's it. Let's proceed to Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. This is also known as the substantial performance or compliance in good faith rule. So, again, this is one of the exception to the rule na dapat ang payment must be complete. Buo ang bayad to extinguish obligation. Dito, recovery is allowed in case of substantial performance in good faith. So, dalawa yung requisites. First, may substantial performance. Second, dapat in good faith. Okay? Hindi pwedeng substantial compliance or performance lang. Dapat in good faith rin. Okay, example. Si Pogi obliged himself to sell 1,000 bags of cement to Ganda for a certain price. Tapos, despite diligent effort on the part of Pogi, okay, hindi niya ma-deliver yung 1,000 bags of cement. Talagang 950 bags lang ang kaya niyang ibigay dahil nagkaroon ng shortage, okay? Nagkaroon ng cement shortage. So, take note, si Pogi, gusto niyang i-comply yung obligation to deliver 1,000 bags of cement. Pero, hindi niya magawa kasi nga, for reasons outside or beyond his control, di ba? Kasi wala siyang pagkukunan, nagkaroon ng shortage. So, meaning, he acted in good faith rin naman. So, Article 1234 provides or tells us that Pogi can recover as though there had been complete delivery. Of course, ililess lang yung price ng 50 bags na hindi niya na-deliver. So, ibig sabihin, si Ganda cannot require Pogi na i-deliver muna yung remaining, yung buong 1,000 1,000 bags of cement bago siya magbayad. Kasi nga meron namang substantial compliance in good faith. So babayaran niya na ngayon si Pogi, although ililess yung price ng 50 bags na hindi na produce or na provide ni Pogi. Okay? Ganda must pay for the 950 bags of cement and then enforce his right to damages for failure of Pogi to deliver the yung kulang, yung 50 bags ng cement. Kasi yun yung sabi ni Article 1334. Okay? 'Di ba sabi doon na obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. That's it. That's Article 1234. Proceed tayo kay Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. So again, it's another exception to the rule na dapat ang payment must be complete, buo ang bayad to extinguish obligation. So it's as simple as despite fully knowing na incomplete or something is irregular sa payment, ngunit tinanggap pa rin ni creditor without expressing protest or objection, then the obligation is deemed fully complied with. This is based on the principle of estoppel, meaning you are now stopped to question. Kasi nung nagbayad, hindi ka naman nagreklamo, tinanggap mo ng walang protest or objection. It's as if nag-waive ka ng right mo. Kasi 'di ba nga pag incomplete or irregular, supposedly pwede mong i-reject ang payment. Pero with knowledge na incomplete or irregular ang payment, tinanggap mo. So, the law presumes that you are waiving your right to reject it. Basta, tandaan lang yung dalawa. Dalawa lang yung tatandaan mo dito. The obligee knows that the performance is incomplete or irregular. Alam niya dapat, okay? And second, he accepts the performance without expressing any protest or objection. So the word accepts, as used in this article, means to take or agree to an incomplete or irregular payment, to take it as sufficient, sapat na, kasi nga, without expressing any protest or objection. So, next question. May required form of protest ba or objection? Kasi di ba without? So, ngayon, kung tatanggapin mo pala, dapat mag-express ka ng objection or protest. So, paano ka ba dapat magsabi ng protest and objection under Article 1235? Does it requires specific forms? Actually, wala naman. Article 1235 does not require that the protest or objection of the creditor to be made in a particular manner or a particular time. So long as gumawa ka ng acts na which clearly shows na you are not satisfied or agreeable to the said payment or performance, the obligation shall not be deemed extinguished. Okay? Walang particular manner or form na required to show protest or objection. Now, Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So, yung first paragraph provides for a rule kung kaninong payment ba si creditor is bound to accept payment at kaninong hindi naman siya bound to accept payment. First, ganito. The creditor is bound to accept payment or performance from the following. First, yung debtor mismo. Kasi siya nga yung may utang or siya yung may obligasyon. So, natural siya din naman yung ne-expect mo na magbayad or mag-perform ng obligation. Second, any person who has an interest in the obligation. Okay? Now, sino ba tong may mga interest in the obligation? Example nito is yung mga guarantor, right? Kung yung property mo ang na-mortgage to secure that payment from your friend, ikaw ay may interest to pay that. Otherwise, mafo-foreclose yung property mo, right? Then, third, the creditor is also bound to accept payment from a third person who has no interest in the obligation when there is a stipulation that he can make payment. Okay? Pag third person or so, mas madali yata pag si stranger, third person or si stranger na wala namang ka-interest dito or wala naman talaga siyang part or wala siyang interest nga dito sa obligation na to, si creditor is bound to accept payment if kahit na nga wala siyang interest sa obligation, kung mayroon namang stipulation that he can make payment, nasa agreement nyo na pwede. Okay? That's paragraph 1. Now, proceed tayo dito sa second paragraph. Ano ba yung epekto ng payment ng third person or ni stranger? Kasi nga wala nga siyang interest supposedly sa obligation, pero gusto niyang magbayad. So ano ba yung epekto nito? Sabi ni Article 12:36, whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. Okay? So, pag yung payment ni third person o ni strangers was within debtor's knowledge and consent, si payor or yung third person or si stranger na nagbayad is entitled to demand from the debtor what he has paid. Either pwedeng reimbursement, pwede rin at eto ha, take note, ito yung pagkakaiba pag may consent or pag wala. Pag may consent, meron siyang right to subrogation. So ano ba tong subrogation? The payor steps into the shoes of the creditor, meaning he is now entitled to exercise all the rights and actions na pwede at available gawin ni creditor. Kagaya nga ng right ni creditor na habulin si debtor at yung right niya against yung mga guarantors, yung mga possessors ng mortgages, as to the penalty, okay? He becomes entitled not only to recover what he has paid, but also to exercise all the rights which the creditor could have exercised. Okay, yun yung subrogation. The payor steps, di ba? Siya yung parang napunta sa shoes ni creditor, okay? The payor steps into the shoes of the creditor, meaning he acquires all the rights of the creditor. Now, paano naman if the payment was without the knowledge or against the will ni debtor? Ang sabi, if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So, meron lang siyang beneficial reimbursement. Okay? Wala siyang subrogation. he is not entitled to subrogation. So yung third person can recover only payment to that extent that the debtor was benefited. So in other words, again, the recovery is only up to the extent or amount of the debt at the time of payment. And unlike if my consent, dito walang rights sa third person to be subrogated to the rights of the creditor, such as those arising from mortgage, guarantee, or penalty. Okay? Let's take an example. Pogi owes Ganda. May utang siya kay Ganda na 1 million pesos. Tapos, itong si Beauty, who is a third person, a stranger to the obligation, nag-offer kay Ganda na siya yung magbabayad ng 1 million pesos. Dito, si Ganda ay may right to accept or not to accept the payment. Kasi nga, Beauty after all is not the debtor at wala siyang interest sa obligation. At wala rin namang nakasabi na nakalagay doon sa stipulation nila na pwede siyang magbayad in behalf of Pogi. And so, pwedeng i-accept or not ni Ganda ang payment ni Beauty. Pero supposed, si Ganda ay tinanggap niya. She accepts the payment from Beauty. So, question, can Beauty recover from Pogi? If so, how much? Right? So, the right of Beauty to recover from Pogi depends upon whether the payment is made with or without the knowledge or consent of Pogi. So, kung without the knowledge or against the will of Pogi, so kung ang actual indebtedness, ang actual utang is 1 million pesos, and Beauty paid the 1 million pesos, then Beauty can ask the reimbursement for 1 million pesos. Pero, if unknown to Beauty, si Pogi pala ay previously nagbayad na kay Ganda ng 500,000 pesos. Such that 500,000 pesos na lang talaga yung utang ni Pogi kay Ganda. And so, in that case, si Beauty can only she is only entitled to be reimbursed up to that amount, up to the 500,000 pesos na utang or natitirang utang ni Pogi kay Ganda. Kasi, yun lang din naman yung amount that Pogi has been benefited. Okay? Beauty can recover the another 500,000 pesos from Ganda, who in the first place should not have accepted the whole 1 million pesos knowing na 500,000 pesos na lang naman pala yung utang sana ni Pogi. That is a case of, again, solosyo indebeti, yung unjust enrichment. Okay? Now, second scenario, kung may consent naman ni Pogi. So, if it is with the consent of Pogi, Beauty can recover from Pogi the 1 million pesos with all the rights of subrogation to the accessory obligations such as if ever merong mortgage, guarantee, or penalty. So, the third person or the payor, the stranger who pays someone else debt, in this case, in our example, si Beauty, ay may right of reimbursement plus subrogation, okay? Meaning, to recover what has been paid and to acquire all the rights of the creditor. Kasi nga, with consent ng debtor. Eto, danan lang din natin. Try to answer while reading. I have prepared some problems. Eto. On May 1, D borrowed from C 10,000 pesos and mortgaged his land payable on May 25. However, on May 10, X, a third person paid C 10,000 pesos without the knowledge of D. When the obligation falls due, D is already insolvent. He cannot reimburse X of what the latter paid C. So, question, can X foreclose the mortgage property? And second question, supposing X paid C with D's consent, Will your answer be the same? Okay, unahin natin yung answer tong letter A. Can X foreclose the mortgage property? No, dahil walang consent. Meaning, walang legal subrogation. Yung right niya lang sana is to ask for reimbursement. However, naging insolvent na si Pogi. Si debtor. So, wala na. Okay? Pero kung letter B, supposing meron namang consent yung pagbabayad ni X dun sa debtor, iba na yung sagot natin. Our answer will not be the same kasi meron ng subrogation. Si third person payer was subrogated to the right of the creditor mortgagee. So, pwede niya na ngayong i-foreclose yung mortgage property. Okay? Now, eto, another problem. A owes B 1 million pesos. Later, A paid 700,000 pesos, leaving a balance of 300,000 pesos na lang. Now, si C, a classmate of A, intending to surprise A, paid B the sum of 1 million pesos, thinking that A still owed B the amount. He did this without the knowledge of A. How much can C recover from A? Dito, C can recover only 300,000 pesos dahil it is only up to this amount kung saan si A was benefited. So, where can C recover the remaining 700,000 pesos? Alam niyo na, kanina nasabi ko rin, di ba? So, from B, who should have not accepted the complete payment. Dahil alam niya naman na partially paid na nga ito, right? Now, take note also that if B acted in bad faith, magiging liable siya hindi lamang sa 700,000 pesos, but also for interest in lieu of damages. Okay? Kasi if she acted in bad faith and it can be proven na yun nga. Now, suppose the payment by C had been made with the knowledge but against the will of A. Would your answer be the same? Yes, the law does not distinguish, okay? Hence, pareho lang. In both cases, the paying stranger can recover only insofar as the payment has been beneficial to the debtor. Yun lang yun. Okay, let's proceed to Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. So, ito na rin yung sinabi at na-discuss natin kanina. And expressly provided siya under Article 1237. If the third person nagbayad without the knowledge or against the will ni debtor, he cannot compel si creditor. Okay? Hindi niya pwedeng makompel si creditor to subrogate him in his rights. So, walang subrogation. Now, I will not discuss this anymore, yung meaning ng subrogation, kasi na-define na natin siya kanina. Diba? Yun yung si third person is put into the shoes of that creditor kasi na-acquire niya lahat ng rights ni creditor. So, okay, anyway, but let's just distinguish subrogation from reimbursement. Pag sinabi mong subrogation, dito kasi may recourse or recourse can be had to the mortgage or guarantee or penalty. Meron pa siyang recourse, pero wala yun kay reimbursement. Talagang kay reimbursement, mag-a-ask ka lang ng payment or repayment. Yung debt, dito naman sa subrogation, the debt is extinguished in one sense, but a new creditor with exactly the same right as the old one appears on the scene. Diba? Nawala yung obligation pero merong bagong creditor with the same right exactly dun sa dating creditor. Kasi siya na ngayon yung mag-exercise ng lahat ng right na meron dun kay original creditor. Dito naman sa reimbursement, si new creditor has different rights. Wala siya, hindi niya ma-acquire yung rights na yun. Tapos, there is more than personal action of recovery kay subrogation. Pero kang reimbursement, there is only a personal action to recover the amount. Diba? More on recovering the amount lang talaga si reimbursement. Or yun lang talaga siya. Whereas sa subrogation, may right siya to recover the amount plus yung other right to go against yung mga kay mortgagee, kay mortgagor, or guarantor. Tapos kung may penalty, pwede niya ring yun, gamitin. Okay? That's it. Tapos nga pala, in both, kay subrogation tsaka kay reimbursement, tandaan nyo lang, there can be recovery. Yun yung similarities nilang dalawa. There can be recovery of what the stranger or the third person has paid. Now, suppose ganito ang nangyari. Let's take another example. Pogi borrowed from Ganda 1 million pesos payable on December 25, 2020. The loan was secured by a mortgage of Pogi's land. So, without the knowledge of Pogi, wala pa rin knowledge siya, consent, Beauty paid Ganda 1 million pesos pa rin. So, ganon. Similar situation kanina. But then, Pogi was benefited to the amount of 1 million pesos. Question, can Beauty claim reimbursement from Pogi? Second, how much? And third, if Pogi cannot pay, may Beauty foreclose the mortgage on Pogi's land? Okay. So, simple. Alam nyo na malabang. Dapat consistent na tayo. Yes, in as much. Ang answer ng number 1, yes, in as much as Pogi was benefited. How much? 1 million pesos. Tapos, if Pogi cannot pay, can she foreclosed? No, because Beauty paid without the consent of Pogi. Di ba nga? If payment by the third person was made without the consent of the debtor, the payer, or the third person ay walang right to subrogation, meaning he cannot compel the creditor to subrogate him in his right, such as those arising from mortgage, guarantee, or penalty. Now, paano naman if yung payment was made by a third person who does not intend to be reimbursed? This will be answered by the next provision, Article 1238. So, payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent, but the payment is in any case valid as to the creditor who has accepted it. So, eto naman is payment by a third person pa rin, pero hindi niya intention yung magpa-reimbursed. Okay? Wala siyang intention na magpa-reimbursed. Ang sabi, ganito kasi yon. In a donation, sa donation kasi, yung rule or yung law sa donation, para maging valid, ang tamang term pa nga is, para in order to be perfected, dapat may acceptance si donee. Okay? Hindi siya sole, discretion ni donor. Pag may nag-donate sa'yo, si donor, pag nag-donate sa'yo, dapat si donee yung tatanggap, kailangan i-accept yan ni donee. Yung pure liberality ni donor. So, the reason for this is, no one should be compelled to accept the generosity of another. Diba? So, malay mo kung ayaw na ayaw mo sa taong yun. So, ayaw mo tumanggap ng kahit anong generosity sa kanya. So, hindi ka rin naman pwedeng makompel. Okay? So, dito sa provision na to, ang sabi, yung payment daw ng stranger or the third person na wala namang intensyon na magpa-reimbursed kay debtor is deemed a donation. So, meaning dahil deemed a donation, kailangan yung debtor's consent. Kasi kung donation siya, meaning itong si stranger ay nag-donate talaga kay debtor, kailangan nga nung acceptance ni donee. Diba? So, in this case, para consistent na rin, kailangan din ng consent ni debtor. Kasi in this case, siya si donee. Right? Pero take note also of the last sentence. Sabi, but the payment is in any case valid as to the creditor who has accepted it. Meaning, if the creditor accepts the payment, tinanggap ni creditor yung payment ni stranger. So, it shall be valid as to him and the payer, although the debtor did not give his consent to the donation. So, valid na rin naman pala. Okay? Para mas malinaw, example ulit. Pogi owes Ganda 1 million pesos. Beauty in behalf of Pogi, ganun pa rin, pays Ganda 1 million pesos against the consent of Pogi. Although, Beauty had previously told Pogi, so sinabihan niya na si Pogi previously, na wala siyang intensyon na magpa-reimburse. Tapos si Ganda accepted the payment by Beauty in behalf of Pogi. Okay, tinanggap ni Ganda yung payment. Question: Is Pogi's obligation towards Ganda extinguished? Na-extinguished ba ang obligation ni Pogi kasi may utang siya kay Ganda na 1 million pesos? Na-extinguished ba? Ang tanong. Tapos second question, pwede bang ma-recover ni Beauty kang Pogi yung 1 million pesos? So answer to number 1, is Pogi's obligation toward Ganda extinguished? Yes, the obligation is extinguished. Sabi nga ng last sentence ng Article 1238, but the payment is in any case valid as to the creditor who has accepted it. Now, sa second question, may Beauty recover from Pogi? Yes, pwede niya rin ma-recover kay Pogi ang 1 million pesos. Kahit na, originally, wala naman siyang intention or walang intention si Beauty na magpa-reimburse. This is because wala namang valid and real donation. Applying yung rule ng previous article na na-discuss din natin, pag yung payment without the consent or knowledge ng debtor, ang marirecover lang ni Beauty is yung amount up to that extent that Pogi was benefited. Right? Malinaw? Pero, kung yung pagbayad ni Beauty was with the consent of Pogi, hindi against the will ni Pogi, may previous acceptance meaning. So, meaning rin, nagkaroon pala ng valid at real donation. So, in this case, Pogi is not liable to reimburse Beauty. Kasi nga, yung payment is considered as donation. His obligation to Ganda is extinguished and hindi niya rin kailangang i-reimburse si Beauty. Had it been na may consent yun ni Pogi, okay? Pero kung wala, di meaning, pwedeng ma-recover ni Beauty yung payment niya from Pogi. Okay? That's it. Hopefully naman naliwanagan kayo. Sana nga. Anyway, proceed tayo kay 1239. In an obligation to give payment made by one who does not have the free disposal of this thing due and capacity to alienate it shall not be valid, without prejudice to the provisions of Article 1427 under the title on natural obligations. So this provision talks about the effect of payment by an incapacitated person. Okay, define lang natin. Pag free disposal of the thing due, ibig sabihin, the thing must be delivered or the thing that should be to be delivered must not be subject to any claim or lien or encumbrance of a third person, meaning free for disposal na nga siya. Wala na siyang mga claims, encumbrances, mga liens. Okay? Tapos, pag sinabi mong capacity to alienate, it means that the person is not incapacitated to enter into contracts. And for that matter, to make a disposition of the thing. Okay? Ang sabi lang talaga ng provision na to is yung bayad ng tao ng incapacitated na tao is not valid kasi nga incapacitated siya. And so, the creditor cannot even be compelled to accept it. It's as simple as that. Well, for now, dito lang muna yung discussion. I will try to upload soonest possible time yung kasunod na provisions. Medyo mahaba na kasi. nakikita ko na nasa 40 minutes na tayo. Okay? So, medyo mahirap na mag-upload pag ganito. I don't know with the internet connection. Something is really wrong in our place. Thank you for watching. If you find this video helpful, please like and subscribe. Comments are also very much welcome. So, see you in our next video. God bless.